Let's bring in a human rights and public interest lawyer, Inibehe Effiong, to this discussion about the crisis looming in the Supreme Court of Nigeria. Welcome, Inibehe. And Mr. Ologo was speaking earlier about the Supreme Court, the apex court of the land being on trial. How do you view this turbulence?
For me, it is a welcome development that the issues bedeviling the Nigerian judiciary is now taking center stage of national discourse. It is particularly captivating for me that for the first time in the over 5 decades of the existence of the judiciary, of the Supreme Court, we have seen the learned justices of the apex court unanimously, I think Nigerians should know this point, that the letter in circulation was signed by 14 justices of the Supreme Court. We have 15 justices, including the CJN, following the retirement of my Lord, Justice
Right, okay.
So we now have 15 justices, including the CJN. So this was unanimous. There was no issue of sectionalism,
or gang up,
or conspiracy, or new or old justices of the Supreme Court. They all signed to this letter. They all appended their signature. That point is important. And I'm saying that to underscore the fact that what my lords, the justices of the apex court have said, cannot be dismissed. But you know, before I came into the studio, I was just going through something on the internet. And I just Googled and I came across a website, uscourts.gov, where you can just look at the budget of the United States Judiciary. This is their current budget, a 78-page document showing you the fiscal year, the congressional budget summary of the U.S. courts. You cannot find out for the Nigerian judiciary. The budget is not available. Nobody sees it. Nobody sees the budget of the judiciary, the same way nobody sees the budget of the State Security Service, the same way nobody sees the budget of the National Intelligence Agency. So that is important. Because when the issue is about inadequacy of funds, one must even have an understanding of the fund that is available and what is it expended for.
and that is rationed.
Exactly. So for me, this is a wake-up call. And I want to stress the point that we are even able to have this conversation because we are talking about the apex court. We are talking about the federal judiciary essentially. At the states, in the 36 states, I don't know how many judges will be courageous enough to come together
out
to query the chief judge in this manner. And I don't know how many judges or chief judges in this country can even come out to tell you what they are going through. So the judiciary has crisis, and that crisis has to be addressed. In the 2022 budget, the budget for the Nigerian judiciary was pegged at 120 billion. It is in this same country that an accountant general of the Federation is accused, I said accused, of stealing 80 billion. And yet, the third arm of government was budgeted just 120 billion in a country whose budget for the annual budget, I think it's over
running to trillions.
16 trillion or more. And you have the third arm of government given a paltry sum.
Because not forgetting that the chunk is going to be
in the same country that National Assembly members are taking home, you know, over 13 million per month in allowances. So we have a leadership crisis that has to be addressed. But in addressing that problem, we must be honest with ourselves that as of today, there are issues of structural reforms. And I want to make the point because we have the Constitution saying that taking the maximum number of justices to 21. So currently the court does not even have
like a full house.
The full house, the number that they are supposed to have. What does that do? What that does is that you have a report where a reputable Nigerian newspaper described the Supreme Court of Nigeria as the Supreme Court of dead cases.
We've even had many lawyers say that they have appeals that dates have been given for even as far as 2024.
2024 is very close.
Beyond.
2024 is very close. So this has affected the productivity of my lords. Look at the complaints that they are making. Matters that should be elementary, matters that should be very simple. They are talking about access to internet. They are talking about lack of judicial assistance, which is even a national problem. Some judges are paying judicial assistance from their pocket. From their pocket. You are talking about availability of diesel in the Supreme Court of Nigeria. This is an abomination that the apex court of a country that is so blessed with resources, is struggling to keep its power on, and the judges now are constrained by working hours. You have judges that were appointed until now, accommodation has not been provided. I read the defense of the Honorable Chief Justice of Nigeria, where he said, oh, it is our budget. Before justices are appointed, there is a process of nomination that has to go through the Federal Judicial Service Commission, that has to go through the National Judicial, the NJC, that has to be approved by the president before justices are appointed to the Supreme Court. So it is not as if these appointments were made unexpectedly. If it was known, as my lord has even asked that some judges, about 6 or so, should be nominated, while that nomination is going on, what provision has been put in place to cater for
their welfare?
Wait,
so this is about leadership.
Now answer the question. Why is the federal government not giving Tanko the honorary treatment?
I think that is an interesting question, but the context is also important. What is of interest to me is for Nigerians to have the opportunity of seeing with clarity whether the budgetary provision for the judiciary, right, under my lord, the current CJN, and even those before him, will properly utilize. Because I have read a report where even the ICPC is complaining about the secrecy of judiciary budget. And you ask yourself, are we a serious country? ICPC has a statutory responsibility to fight graft, to fight corruption. And then the ICPC is now talking, becoming a toothless bulldog, going to the press to complain. Whereas, if they have indication, if there's prima facie evidence or clear, convincing proof of misappropriation of judiciary budget, all that they simply need to do is to invite the chief registrars of the heads of courts, of the various courts, because by the way it is done is that the chief registrars are the accounting officers, but the CJN are basically the signatories. So if, for example, they want to buy 1,000 liters of diesel, the chief registrar is the one to read the memo, is the one to determine how much the quantity that should be bought. But the CJN must sign off for it. So ultimately, the power resides with the CJN. And of course, the other heads of courts. It is for the ICPC to call them and say, can we understand why? In fact, this is even an opportunity.
Absolutely, because what is stopping them now? The Senate has waded in the matter. The body of benchers, as also says a former CJN, Abdullahi, is also, going to head the committee that it has drafted to address this. That was according to Chief Olani Peku over yesterday or thereabout. Even the NBA has spoken. So what's stopping the EFCC and the ICPC from intervening on its own, or do I have to write a petition to this effect?
What have they intervening? I mean, before...
Well, they did that to not
on its own.
With the intention, of course, it was the code of... We must...
Code of Conduct Bureau,
not... It was
not Code of Conduct Bureau, yes. And they found the right institution to do that. But they found the right institution to do that. But there's a right institution to do this one too. They have not done anything.
So what's the question still begs to be asked?
We can all agree that the removal of His Lordship Justice Walter Onohen remains a stain on the Nigerian nation. The process in which that was done, that you will have a tribunal. One man sits there and say, I am giving an ex parte order suspending the Chief Justice of Nigeria. No serious country can tolerate that. So it looks like the ghost of Onohen, the removal of Onohen, is still haunting the Nigerian judiciary, is still haunting the Nigerian state. But let us not lose sight of the issues. As that today, the Nigerian judiciary is grossly underfunded. Grossly underfunded. I go to some courts in this country, and lawyers are still sitting on they can't even find.
Well, but is that an excuse? Is that an excuse for misappropriation?
It is not an excuse. What I'm saying is that the issue of transparency has to be addressed. I have referred to the case of the US, where you could just go on the internet and you can see the budget of the US courts for the year, how it is spent, what is proposed. I said that is not available for our courts. I'm also making the point that in addressing that, we must not lose sight of the other issue, which is the underfunding. I am telling you that I have been to courts in this country where lawyers are still sitting on cement slabs.
Yes. Then they say there's
It is that bad.
underfunding. Is that the reason for rationing? I quoted Sophocles, and I said, "Thou shalt not ration justice." Is that the issue? Is it the fact that we don't have much? Therefore, I, as chief executive of not of the executive branch, of the judicial branch, we have to gather all of the small things, because it's just like somebody who has a big appetite and is strong, and they put a big bowl of eba in the center, and he has the capacity to just grab most of it and leave the others
to manage the few remaining.
Is that what is going on? Almost like
they're just allegations.
They're not giving us enough, so it cannot trickle down. Let them give us more money. If you cannot manage a little, how can you manage a lot?
But do you even see this going as far as everyone, would expect that it goes far? We even understand that there has been a case in court instituted at the Industrial Court instituted by Sebastian Horn, a senior advocate of Nigeria, on this issue of welfare of judges, on this same issue of, enhancing the image of the general judiciary. Do you see this going far? Or are we just likely to come and talk about this again, years after, unresolved?
If you look at the Constitution, particularly Section 81 and Section 160 of the Constitution, the judiciary is given a first-line charge. Because those provisions, the combined effect of those provisions, is that any amount standing to the credit of the judiciary in the funds from the Consolidated Revenue Fund of the Federation shall go directly to the National Judicial Council for disbursement to heads of court. So the proper thing should be that every year the judiciary is supposed to submit its budget directly to the National Assembly. The National Assembly is supposed to now appropriate. But what happens now is that you have the heads of courts preparing the budget, and they send it to the executive. The executive now tinkers with it, and they ultimately determine what they want to send to the National Assembly for appropriation. So that has to be addressed. Part of this is the need for some level of constitutional amendment to strengthen the independence of our courts. Because, as I said, we're having this conversation because it involves the federal judiciary. Some state chief judges in this country, if you know what they are going through, and the last time I was there, I cited an example of a state where the yearly almanac of the judiciary, the governor refused to release money to the CJ because he was not happy with the CJ. And the guy who was given the contract came to me to say that he's being owed. And by the time I asked him who is owing you, he said the judiciary. What contract did you deliver? He said almanac. He printed almanac and they have not paid him. And the matter lingered. This is what is going on. So you have where chief judges are basically going to kneel down
before governors,
because governors control capital expenditure while the federal pays the salary of judges.
What is also going on is a case in which we have hubris. We'll address that later. I have stories of states, of the chief judges who have done the same thing that the CJN is being accused of. There was a story of a chief judge whom the governor told, who wanted to chair the contract committee. And they said, no, you cannot do that. They ran and do that. He brought his cousin to chair it, and after chairing it, he gave the contract to his brother. You see, there's a case of a state now where the chief judge, I don't want to mention them, they went into the accounts. As we are speaking today now, a state chief judge, people in the political society are begging the governor not to reveal what he has done with the account. There's another one was who not long ago, a chief judge in a state, a woman. And this case was also terrible, that the governor was also begged not to spill the beans, and they should just take everything quietly. So we have a situation where it is not just the CJN, that it is right from the top to the bottom that we have this problem. Inside the problem, they say heads of courts, that they have become. So what is going on with the CJN now? That 14 justices are saying we cannot take this anymore. And the CJN is standing. What is the CJN standing on? What is making him feel
Legality.
so strong in spite of the complaints? Is it hubris?
The CJN is basically the alpha and the omega. The Constitution has so skewed the powers of the Chief Justice. It is a point that the country has to address at some point. At a time, the CJN is the head of the Supreme Court. The CJN is the chairman of the National Judicial Council. The CJN is the chairman of basically all the important institutions within the judiciary. The CJN has the power to appoint members of the NJCs, basically almost all of them. They are appointed by the CJN. And that becomes very difficult. Who now checkmates the Honorable Chief Justice? And I'm not speaking particularly about Tanko. I'm speaking about the institutional issue.
Even the
Nobody
Chief Judges
in Nigeria
of the state
today can checkmate the CJN. And at the states, if I tell you some of the experiences I have seen, you will weep for this country. So something has to be done to address what looks like the inability of institutions or mechanisms to checkmate the powers of heads of courts. I am not saying that the heads of courts should not be given powers to control the courts. I am saying there must be some form of checks. Because some of the judges and justices are complaining in silence. They cannot speak. You go to their courts, no communication gadgets. You go to their courts, the basic things are not there, and sometimes they can't even read
and that is also what the
courts.
CJN is riding on, saying that judges generally should be seen and not heard, even though they have to suffer in silence well until this latest outburst now from the highly revered GSCs. Inibe Effiong, we'll leave it at this point now. So much to say, but then time isn't our friend as always. Thank you very much for your contributions.
My pleasure speaking with you. Thank you.